Estate planning is one of those things that most people put off until it's too late. But making mistakes here can cause your family a lot of headaches like court battles, family fights, or losing control of your money. In this video, I'm going to walk you through the top 5 estate planning mistakes that people make and how you can avoid them to protect your family and your legacy. Hi, I'm attorney Aaron Miller, and about 15 years ago, I saw how tough it is for families when they lose control of their assets. So I decided to dedicate my career to helping people plan and protect their future. If you'd like to speak with a trusted attorney, give us a call today at 214-292-4225. Now let's dive into the top 5 costly estate planning pitfalls, and I'll show you exactly how to avoid them. Pitfall number 1, going the DIY route. The internet is full of tempting DIY estate planning templates and legal forms that promise to save you time and money. It might seem like a quick and easy solution to draft your own will or trust, but this is one of the biggest mistakes that you can make. Estate planning isn't a one-size-fits-all process. Your financial situation, family dynamics, and long-term goals are unique, and your estate plan should be as well. DIY documents often miss critical details or legal nuances that can cause huge headaches for your family down the road. For example, a poorly drafted will can be challenged in court, leading to costly litigation. Or if your trust isn't properly funded, your assets might still go through probate, defeating the purpose of the trust entirely. These mistakes can end up costing your loved one much more in time, stress, and legal fees than you would have saved by skipping professional help. Pitfall number 2, not putting everything in writing. Another common pitfall is relying on verbal promises or informal understandings instead of putting your estate plan in writing. In estate planning, only written documents are legally binding. Verbal promises about who gets what can lead to confusion, mistrust, and often family disputes. Let's say you've told your children verbally that they'll inherit some particular thing, but it's not included in your will or trust. After you're gone, the courts won't recognize those promises, and your estate will be distributed based on the legal documents on file, which may look very different from what you intended. If your wishes change, it's vital to update your legal documents accordingly. Amending your will or trust through your estate planning attorney ensures your current intentions are clearly reflected. Remember, keeping all your estate planning documents organized and accessible to your trusted attorney and family members will prevent unnecessary delays and confusion. Pitfall number 3, failing to update your estate plan. Estate planning is not a set it and forget it task. Life changes, marriages, divorce, births, deaths, or even a move to a new state. They can all impact whether your plan still works the way you intended. Here's an example. Outdated powers of attorney. If the person you named years ago has since moved, passed away, or you've just lost contact, they may no longer be the best choice to manage your finances or healthcare decisions. In an emergency, that gap can cause delays, confusion, or even court involvement. The same goes for your will or your trust. If you've had more children or if your relationships have shifted, failing to reflect those changes could unintentionally leave someone out or leave someone in who shouldn't be there anymore. That's why estate planning professionals recommend reviewing your documents every 3 to 5 years or any time that there is a major life event. Keeping things current ensures your plan works for your life now, not just how it looked years ago. Pitfall number 4, not planning for incapacity. Estate planning is often thought only in terms of what happens after you die. But planning for incapacity is just as critical. Incapacity means being unable to make decisions for yourself due to illness, injury, or cognitive decline. Without proper planning, if you become incapacitated, the court might have to appoint a guardian or conservator to manage your finances and healthcare decisions. This process is expensive, public, and often stressful for your family. To avoid this, your estate plan should include incapacity planning documents such as powers of attorney and healthcare directives. A durable power of attorney allows a trusted person to handle your financial matters if you become unable to do so. Similarly, a healthcare power of attorney lets someone make medical decisions on your behalf according to your wishes. Failing to include these tools leaves your fate in the hands of the court rather than someone you trust and can delay critical decisions during emergencies. Pitfall number 5, failing to fund a trust. Creating a trust is a powerful way to control how your assets are managed and distributed, avoid probate, and protect your beneficiaries. However, simply establishing a trust isn't enough. Funding the trust is essential. Funding means transferring ownership of your assets from your individual name into the name of the trust. This includes real estate, bank accounts, investments, and personal property. If you fail to do this, those assets remain outside of the trust and will be subject to probate, potentially causing delays and costs your plan aimed to avoid. For example, you might create a revocable living trust to pass wealth to your children, but forget to retitle your home or update your bank accounts. In this case, your home would still go through the probate process and be handled separately from your trust assets. Estate planning is one of the most important things you can do for your family's future, but it requires careful attention to detail. Avoiding these common pitfalls can save your loved ones from unnecessary stress, legal battles, and financial loss. That's why it's crucial to have clear, compassionate guidance every step of the way so you can have the confidence that your legacy is secure. If you're ready to start planning or you want to understand your options, give us a call today at 214-292-4225 to schedule a consultation. We'll walk you through what makes sense for your situation and help you protect the people who matter most. And if you found this video helpful, don't forget to like and subscribe. We've got more answers coming your way. Click on the next video right here to stay informed.